Okay, good afternoon. This is the House Judiciary Non-Civil Committee meeting. We've got several bills on the agenda. I'm going to have to excuse myself at 2 o'clock. The Vice Chair is going to go ahead and take over at that point, and I hope to be back as soon as I can. That being said, just looking at the agenda, we may be able to expedite these bills. That's the hope and the prayer. Senator Crosby, I know we'd spoken yesterday. You ready to go, sir?
Yes.
All right. Just ask you to come forward. Mr. Spayhouse, I see you stalking the microphone as well. Sure, absolutely.
I was waiting on the invitation, Mr. Chairman.
And also we have Andy Welch, who will chair the bill in the House.
Okay.
And also Officer Aaron Brinkman, who is an officer with the Gwinnett County Sheriff's Department, and I think could relate some personal experiences.
Okay.
To
Which one do you want to do first?
Well, I'm sorry, I'm getting ahead of myself.
That's all right.
All right, let's go with 352.
Okay.
And I'm going to ask the distinguished Solicitor General from Henry County if he'll take the lead on this. And there's been some changes, and of course it left the Senate some additions, and he's well familiar with those, and I think has talked with everybody who has a position on those particular items.
Okay.
Okay. Thank you, Mr. Chairman. If I could, the bill that came out of the Senate was simple in that it created the authority of the municipal courts to create the position of prosecuting attorney. As you know, I represent the Solicitor General's Association. I have formerly served as a municipal solicitor prior to taking office as a Solicitor General, and recognized then that despite the fact that there are municipal solicitors all over the state, there's no clear-cut authority for some of these positions. So what this does is it goes into 1518, the prosecuting attorney section under courts, and creates those positions. While in 1518, there was a couple of other provisions that needed dealt with that we agreed then that we would bring over here as a substitute. And if the chairman would prefer, I'll go through each section right quick and discuss it. Specifically, Section 1 and Section 2 address, and again we address this in the creation of the municipal solicitors over on another page, and I'll point that out when we get there. Last year, this General Assembly passed a statute, which is 40-6-163, which authorizes the civil infraction and enforcement of cameras that deal with the passing of school buses. The problem with the way that was written at the time it was written was nobody went into the prosecutor's statute and clearly gave the prosecutors authority to prosecute civil infractions of this nature. We only have the authority granted by the General Assembly, and our civil jurisdiction is very limited, and neither the district attorney nor the Solicitor General statute and then now the municipal prosecutor statute have any reference to that code section. So that's what Section 1 and Section 2 do, is it adds gives the civil authority to prosecute 40-6-163, which is the school bus camera statute. Now, in this substitute, somehow or another some language got picked up from a very early version that gives us a more broad civil action. The senator's gonna ask that we go back and limit that. I specifically point you to line 19, and it says "and to prosecute," and it inserts "other." We're going to ask to take that back out. That is more broad than what we want this code section to do. We're simply asking for authority to enforce the civil provisions of the school bus cameras that were passed by the General Assembly last year, not any broad civil discipline. We're going to do the same thing on line 25 in the first one. I'm sorry, the first section, Section 1, is District Attorney. The second section is Solicitor General. We're going to do the same thing. The "and" the "other," take that out of there. Section 3 is another provision that was passed by the House year before last and never got a full Senate hearing. It deals with a situation when there is a vacancy in the office of Solicitor General. When this is similar to this is actually language that copies the district attorney. When there is a chief assistant solicitor general or there is a full-time assistant solicitor and the office of solicitor general becomes vacant, this provision says that that full-time prosecutor can assume those responsibilities until there is a successor appointed by the governor. Now, the only thing that's ever been controversial about that in the past was we tried to provide a circumstance to deal with when there was no assistant solicitor. The way this has been dealt with, so to avoid any kind of conflict whatsoever, is Section B starts at line 38 of Section 3, deals with the situation when there is no assistant solicitor. It simply allows the judge of the court to request the district attorney of the circuit or another solicitor general of the state to prosecute the cases in the time between the vacancy in office and a governor's appointment. So there'll be no appointment. There'll be no local person that is given any upper hand in any kind of election or any kind of anything like that. This is simply giving the authority to another prosecuting attorney that is elected to deal with prosecution in that court until the vacancy is dealt with. So that is what Section 3 does. That's how it deals with full-time solicitor generals and part-time solicitor generals. Section 4 starts the provisions about creating the municipal court solicitor general or the solicitor. First of all, it has to authorize the governing authority to to employ or create the office of prosecuting attorney, which generally has to be done by municipal charter or not by either charter or by action thereof. There's some provisions in here about registering with the prosecuting attorney's office, the prosecuting attorney's council, so that there is some database of who's out there and who's doing it. It also allows us to help coordinate training and other aspects of that. It authorizes, much like the statutes now related to municipal courts, that the prosecuting attorney can be a solicitor general or a district attorney if that's the way the municipal corporation wants to do it. It doesn't require it, it just authorizes it. The next section, which creates 151892, is simple statute language that copies kind of similar to the solicitor general now about them being a member in good standing. Originally there was a provision put in here saying 2 years admitted to the practice of law. I'll tell you where that comes from. In Georgia right now, to be a judge, you have to be admitted for 7 years. To be a district attorney or solicitor general, you have to be admitted 3 years. So 2 years was picked up so that you don't necessarily hire a lawyer right out of law school to be dealing with these kind of issues. But we'll defer to the wisdom of the committee about that. We do believe that they will have to be a member in good standing and admitted to practice in the appellate courts, but the time frame, of course, is we'll leave for that. It creates 151893, which is a oath of office. We can't have a prosecutor out there that doesn't have an oath that they've got to follow, so that oath is very similar to the one taken by myself and the district attorneys of this state. The next provision is 151894. It simply tracks the DAs and the Solicitor General statutes about if they're part-time, then they can practice law, but they can't practice in the court in which they prosecute. If they are full-time, then they're prohibited from practicing. I think that would affect very few municipal solicitors in this state, but that is language straight out of the district attorneys and the Solicitor General statutes. 151895 is language very similar to what happens when there's a disqualification of the Solicitor General or the District Attorney, so that language is copied. 151896 goes into the actual authorities. This is taking provisions from the other prosecutor statutes and laying out what would affect a municipal prosecutor. I point to you also that we included 40-6-163, which is the school bus statute for civil enforcement. And again, it goes through the various things, including the ability to prosecute the cases, to defend the cases. If they go into superior court or the appellate courts, this gives that prosecutor the authority, just as the rest of us do, to defend the actions thereof, and also the habeas corpus if there is some challenge to what goes on there. It also has the requirements, like it does in our statutes, about attending the sessions of court, administering oaths to the various officers, to performing the duties required. Some specific authority that we believe needed to make clear was that the prosecuting attorney of a municipal court would have the ability to not only file but amend charging documents, to enter null process, to file accusations, the various things that we do on a daily basis as prosecuting attorneys, rendered the judgments to writing, to request the utilization of any assistance if that is authorized by the local authority. On to page 6, the 151897 just simply authorizes the municipal corporation to compensate the prosecutor for any kind of expenses. 151898 is a similar provision about compensating employees or contractors that may be required. And just verifying that if there is an assistant, that they serve at the pleasure of the actual prosecuting attorney, which is what 151899 does. And then Section 5 had been added to. What this does is it provides authority for the municipal courts in the municipalities to try and dispose of violations of 1613.2, which is the possession of drug paraphernalia code section. I believe that came from a member of the judiciary that recommended that that's been requested by some of the municipal courts to deal with some of the things that are transpiring in these cities. But it specifically deals with the drug-related object statute and makes clear that the municipal courts can try that as in their city courts. And that is the gist of the bill, and I'd be glad to field any questions from members.
Questions from members of the committee? Mr. Coomer.
Thank you. Two quick questions. One, as I read it, there's nothing in the bill that requires a municipality to use an attorney to prosecute cases. Is that correct?
Nothing that requires it, no, sir.
Okay, so municipalities that just allow the arresting officer to prosecute can continue to do that, correct?
That's right. This authorizes the creation, but it does not require the creation.
And was there anything in here that addresses requirements for municipal judges?
No, sir.
Okay, thank you.
Mr. Atwood. Mr. Pack.
Thank you, Mr. Chairman. Quick question on line 77, 78, talking about the State Bar of Georgia. Just refresh my memory. Wasn't there a dispute, I think, last year or 2 years ago regarding whether or not someone has to be a member of the State Bar versus a practicing attorney of any bar for 7 years to be a judge? My question is, what if somebody who is, and this may probably not come up, but someone who's a very experienced person of another state moved down, but not a member of the State Bar of Georgia for 2 years, that person is disqualified from being appointed a prosecutor?
Yes, sir. This would make that clear. I would argue that our statute that prohibits the practice of law unless admitted to practice in the state of Georgia would already prohibit that behavior.
Right. The question is, why 2 years versus
2 years was in there again, creating at least some requirement for some experience. I again will defer to the wisdom of the committee on that. That was written in there.
Well, I think you said it before. It had been 3 years.
It's 3 years for the Solicitor General or the District Attorney.
Sure it's not 5 years for the DA?
I think it's three, but I'm not sure.
I just got
It's 3. Thank you.
the word. It's 3, which seems low. But
Yes, sir.
separate and apart from that,
Yes, sir.
I think maybe it's an availability issue in terms of
Certainly. Yeah, I think
3 years for the county solicitor, and obviously this is a much smaller jurisdiction.
Right.
The pool may be a little smaller, especially in some jurisdictions.
Certainly. I think
I'm just guessing at that as a rationale.
Yes, sir.
Any further questions? Seeing none, Mr. Patel, I saw that you're here to offer your support.
Well, we do have some questions.
Okay. Did you want to be recognized to testify? Come on forward. And Mr. Patel is the only witness signed up we'll then hear from him and then take action.
Thank you, Mr. Chairman. As mentioned, this bill has substantially changed since it crossed over, and we're just now taking some looks at the changes. And one of the big concerns is actually that 2-year provision. I think, from personal experience, my previous job was as assistant city attorney and city solicitor down in Brunswick, and I didn't have 2 years in good standing with the State Bar of Georgia when they appointed me as city solicitor, and I think that has helped me grow as an attorney. And I think there probably are a number of city solicitors that might be a year and a half in, or as Representative Pack mentioned, might have come from other states, and I think that is a serious concern because that could affect a number of cities throughout the state. I completely understand being a member in good standing of the State Bar. The 2-year provision is a big concern. One of the other concerns is, and I may be incorrect because this is the first time looking through this language, but it appears that the municipality is authorized to hire a city solicitor, a prosecuting attorney for their municipal court, and then it looks like in line 68, it seems to suggest that if they don't hire it, then they should contract with the district attorney. I believe there are municipal courts throughout the state that don't have city solicitors, that just rely on the police officer coming forward and testifying, and then the judge listening to their testimony and the testimony of the witness and making a decision. And it might be a mandate to hire somebody, which
I don't read that as being, I'll defer to counsel, I don't read that as being a mandate. I read that as being authorized to do so, but not a mandate. But let me get counsel's opinion on that. Okay.
As for the other sections of the law, there could potentially be some concerns as far as mandates go, but for the most part, it looks like a lot of the sections of the law, especially Section 5, and it looks like from line 110 on, actually, look like they might be very good for prosecuting attorneys and cities. But again, this is these are substantial changes from the version of the bill that came over from the Senate side. So we may have concerns after we look at it deeper, and we'll be glad to talk to Judge Crosby if we see any. That 2-year provision, I think, would cause some issues throughout the state. I don't have numbers on how long city solicitors have been practicing in different jurisdictions, but I believe that there are certainly going to be places where newly minted attorneys or attorneys from other states are in that city solicitor position, and this would cause those cities to have to change their attorneys.
Mr. Vice Chair.
Just in light of that, I wanted to ask Mr. Spahos a question. What are currently the requirements as far as in case law that the Supreme Court may have laid down about cities being required to have prosecutors or judges? And I know that there's been an issue in the past about judges being put in the position of having to basically, actually present a case or aid in the presentation of a case, in which that's not allowed. But what about a requirement for prosecutors?
It's not crystal clear. There are those of us that hold the opinion that that a police officer can quickly step over the line to practicing law and prosecuting his own case. It's kind of one of those areas that is gray, and that, quite frankly, the line's often stepped over when there is a lack of prosecutor there. The best practice is certainly for there to be a prosecutor, so that this line of violating our pretty broad definition of practicing law without a license is not violated.
Right, because the officer is not actually representing himself; he's representing the municipality or the state. And as a follow-up, do you know how many municipalities right now have no prosecutor whatsoever other than just police officers?
I don't have that number off the top of my head. I know my former city doesn't have a full-time prosecutor anymore, and I'm not even sure if they have a part-time prosecutor anymore because of budget constraints. And
Okay.
that's where the concern runs in. A lot of cities are running through budget constraints, and if there's a city out there that had to make a cut of a city solicitor, this might put them in a position where they're going to have to spend money where they hadn't planned on it, you know.
Why would a cut of a city solicitor be necessary as a result of this bill?
And after hearing the testimony of Ledge Counsel that it's not a mandate, I think that, you know, might address those concerns to just hear that. Again, first time looking through this language, but that's basically it. If it's not a mandate, then there shouldn't be a problem.
Right. And one other thing, going to that 2-year provision, I noted that appears to only apply to the appointed prosecutor, but you could have assistants that don't have to meet that requirement. Is that right?
And this makes for that provision.
Okay.
The assistants would not have to meet that requirement. Again, you got to keep in mind the way we got to the 2 years is the first version and the provisions about the solicitor that we asked to be taken out in the Senate version grabbed the Solicitor General statute and said shall have the same duties, responsibilities, authorities, and requirements. Well, that was very broad, overly broad, and that would have grabbed a 3-year requirement. So we were stepping back when we went to 2. And again, if this is a point of contention, we started at 3, we're at 2. As long as they're a member admitted to practice and in good standing, I don't think it's
But it does not
that
affect
important
the
to the
assistant
bill.
solicitors.
Right. It does not affect
Any
assistant
assistant would be
solicitors.
the solicitor.
That's correct.
Okay. Mr. Hightower.
I was just going to comment on the 2-year provision, just because I've practiced for 2 local city municipalities, and I know they're strapped a lot of times with money, and a lot of times some of your younger attorneys are willing to do this at a much more reasonable rate for the cities. 2 years is not that bad of a requirement, but I do know that some cities, they look for the younger attorneys just for that purpose and that purpose alone. And hopefully those cities will take it upon themselves to do a proper interviewing process to get the appropriate individuals for that position, because it's in their best interest that they have a good prosecutor there, because they need someone there. With that said, I also know that sometimes we do need some type of requirement because prosecutors have a lot of discretion, and sometimes you want someone with just a little bit of experience to know how to properly use that discretion, I guess you could say. So there's some pros and cons to both, and I see both of them. But
and Representative Hightower, I'm with you. Can tell you a couple of horror stories on having to go back behind some municipal solicitors. In my role as Solicitor General, we have concurrent jurisdiction in those cities, and have had to go behind and do some things because a prosecutor was not qualified or didn't know what they were doing, and so that was. I mean, selfishly, we do want to see somebody with at least some experience in those roles. But
Mr. Ramsey.
This is a question for counsel. Maybe I'm just a little slow on the uptake here. Reading, starting at line 68, in conjunction with subparagraph A, starting on line 55. Subparagraph A contemplates the authorization of authorizing the creation of the office of prosecuting attorney of the municipal court. Then 68 says, in lieu of creating that office, you can contract. Doesn't that set up? This is to Jill, a kind of a binary either/or choice without an option 3 of not following option A or option B? Okay.
In the absence of being expressly prohibited.
Okay. In reading D, it seems to suggest. I guess you can read it both ways, but in lieu of creating the office of prosecuting attorney, the governing authority shall be authorized to contract. It seems one plausible reading is if you're not doing A, you've got to do. In lieu of doing A, you can do D, but there's not really
It definitely has a roadmap look to it, but the fact that it authorizes as opposed to a mandate. more suggestive. Mr. Coomer.
I'm just going to follow up on the discussion of the assistant prosecuting attorney. If you look at lines 174 through 176, that's where the assistant's requirements are set out, and there is no time requirement, just that they be a member in good standing. So that actually does answer the question.
Thank you. I see no one else has signed up to speak. What is the pleasure of the committee?
Move to pass.
Move to pass by the vice chair. Is there of Senate Bill 352 by substitute LC 295243 ERS. Is there a second? Second by Mr. Atwood. Are there any amendments? Mr. Coomer.
We would ask that it be amended to strike those provisions in 1 and 2 that we discussed.
Mr. Coomer, you want to offer that amendment? Mr. Coomer, you want to repeat your amendment?
Offer that amendment to strike that language in 1 and 2 that we were discussing earlier.
And that's just so council can be clear on line 19. That's to strike the words "and to prosecute," as well as striking the word "other." Is that correct?
That's correct.
Additionally, it is to strike the words on line 25 of "and to" as well as "other." Correct?
And
No, I'm sorry.
that's
Help us out on line 25 then, Mr. Spayhouse.
no. We want to be able. We don't want to change current, but the only thing we're trying to do is expand it further to do 40-6-163 and not any civil actions.
We currently have the ability to prosecute or defend any civil action. That's current law. The only word that's new there.
To prosecute civil actions. Okay. I apologize. It only got changed back in section 1. It didn't get changed back in section 2.
Okay. So is the proposed amendment by Mr. Coomer?
Those read exactly the same. So, the and to prosecute on line 19 comes right after 163, and the same thing is on line 25 and to prosecute.
Okay. The problem is it's the when authorized by law provision now, never authorized the prosecution of 40-6-163. So what we're trying to do is make sure that we're not trying to limit the current jurisdiction, but we're trying to have this body authorize the prosecution of this or the enforcement of the civil penalties of 40-6-163, but not to broaden it any more so than it currently does, if you follow what I'm saying.
Yeah, so would it be better on looking at section 2 of the bill if after the word "and" on line 25 we inserted the words "and when authorized by law"? to
Okay.
prosecute?
Yes, ma'am. That would put it back. That would make it logical and put it back where we're at. The only thing we're adding is 40-6-163.
Let me ask counsel to restate that when she's ready.
So line 25 would read, fourth in code section 40-163, and when authorized by law to prosecute or defend any civil action in
Yes, ma'am, I agree.
and there's no change to section 1 of the bill,
Okay. Any objection to the amendment?
unless you want to get rid of the word "other" on line 19. I'm sorry.
It's all right. Please.
To prosecute. Right. I think the other is an expansion of jurisdiction. Do you?
It was in the draft it was given to me, so I
Current law is any civil action.
Yeah, that makes the language consistent throughout to
Okay.
have the word "other" there.
so no change to section 1.
Okay. Counsel, can you just go ahead and restate on for section 2? After the word "and" on line 25, when authorized by law.
To prosecute or defend any civil action in
Okay. So we're striking the word "other" on line 25. Any objection to the amendment? Hearing none, the amendment's adopted. Are there any further amendments? Mr. Ramsey.
I'm not sure if I'm going to offer this amendment or not, but I'm going to ask the author and counsel just if I read even a slight ambiguity into line 68, I think it would serve us well to fix it. Maybe not, and I'll defer to the wisdom of the committee, but would it hurt the bill or alter the intent of the bill if on line 68 we deleted starting in all the way to the comma after municipal court, capitalized the word the, and inserted on line 69 between shall and be the word also? So that section would then read, the governing authority of a municipality shall also be authorized, and the rest of it will remain intact. I think it clarifies that if you don't do A, you're not obligated to do D. It's really more of you just make clear that you're authorized to do both, but you don't have to do either. And if it's unnecessary, if the chairman says, or
no, I mean, I think the gentleman's concern is what he said before, but it has the appearance, although not the legal effect, of saying it's one or the other.
Right.
Even the appearance, but not the effect. I'd want to ask the author his opinion on that.
I think that would be fine as suggested.
Okay. So to restate Representative Ramsey's amendment, it's on line 68, beginning at D. To just go ahead and strike that entire line through the comma, then get to the word the at the end of the line, capitalize the, so that the section will read, Section D in line 68 would begin, the governing authority of a municipality shall be authorized.
and it would it would insert the word also between shall and be, shall also be authorized.
Shall also. Is that unclear to any member of the committee? Is there any objection to the gentleman's amendment? Hearing none, the amendment's adopted. Any further amendments?
Mr. Chairman, it has been suggested that perhaps we could take out the 2-year requirement and just require that this prosecuting attorney be a member of the state bar in good standing.
Mr. Vice Chair?
Just had a quick amendment on line 73. I think the word contact needs to be changed to contract.
Line 73, strike the word contact and insert contract. Just a technical change. Any objection to the amendment? Hearing none, the amendment's adopted. Senator Crosby, that's a substantive amendment that I would open up to any member of the committee if they want to go ahead and offer it. That's why I need to go ahead and do it.
I think everybody on this side of the table is agreeable to that, Mr. Chairman.
Mr. Pack.
I'll offer that amendment. On line 77, I move that the words for at least 2 years be stricken.
Mr. Pack offers the amendment on line 77 to strike the words for at least 2 years. Is there any objection to the amendment? Hearing none, the amendment's adopted. Are there any further amendments? Senator Crosby, I want to just check we're in good shape now.
Yes, sir, I believe
All
so.
right.
Thank you.
Seeing no further amendments, any further discussion? Seeing none, we have a motion to do pass by substitute of Senate Bill 352. All in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, the motion is adopted. Senator Crosby, while you're there, Senate Bill 441.
Okay. Thank you, sir.
Senator, did you say that you wanted Representative Welch to carry
Yes, sir.
that bill 352? Is that correct?
He is considered to do that, yes.
And now you've got Senate Bill 441.
All right. Thank you, Mr. Chairman, and distinguished members of the committee. This is a relatively simple bill, and this came about at the request, actually, from some police officers in the sheriff's department in Gwinnett County, and other places around the state, and it's increasing around the country, where there's been a problem with police officers having focused upon them, either on their person or perhaps in their vehicle, laser from some form. And of course, when a police officer sees a laser coming at him or his car, then naturally the first thing he thinks is there's a bullet following that laser. and it creates a very dangerous situation. And we do have Officer Aaron Brickman here, who is employed with Gwinnett County Sheriff's Department, I think can relate a personal experience or two in this regard. And then the second part of this bill relates to airplanes or helicopters. Thank you, sir. And it simply provides that if you're guilty of violating Section 1, which deals with I guess pointing a beam or a laser at a police officer, if you do that intentionally and you know that the police officer is lawfully acting within the course and scope of his employment, then that can be a felony of a high and aggravated nature, and of course can carry a penalty from 1 to 12 months, up to 12 months, and or $5,000 fine. Now, in regard to Section 2 concerning airplanes, there is a difference in the penalty. That provides that shall, if you found guilty of that, you shall be guilty only of a misdemeanor, which would carry a penalty from 1 to 12 months, and of course provides for a less penalty than a high and aggravated misdemeanor. But anyhow, with that said, I don't think I did a very good job of explaining this bill, but I would like to have give the officer an opportunity to say a word or two. Sure, please, officer. Tell him your name and where you're employed, please.
Officer Aaron Brinkman with the Gwinnett County Police Department. Basically, this bill is important to us as police officers for two reasons. The first reason being lasers pointed at actual police officers. In our training and experience in dealing with firearms and even now the advent of tasers, a lot of times lasers are used as aiming devices for these. And so when an officer encounters a subject who is pointing a laser at him, that officer would be led to believe that that is not simply a laser, but is a firearm being pointed at them. And so it puts them in a bad situation where they have to quickly determine, is that a laser pointer or is that a firearm? Do I need to shoot this person and use lethal force, or is this somebody playing with a laser? And it puts them in a very, very bad position where they may end up using lethal force in a situation that wouldn't generally call for it, but they have to, in a split second, decide if this is lethal or not. The second dangerous scenario is when lasers are pointed at aircraft. I've spoken with the director of our aviation unit. In the last year, we've had 2 incidences where lasers have been pointed at our helicopter while patrolling Gwinnett County. When they're patrolling at night, the cabin of the helicopter is illuminated with red lights to maintain their night vision. When a laser strikes the windshield of the helicopter, it refracts and it lights up the entire interior of the helicopter as if someone has turned on a light switch. This completely disables their night vision, and it's as if somebody shined a bright flashlight in your eyes while standing outside at night. You can't see. So they're flying a helicopter at low altitudes over heavily populated areas and can't see where they're going. This can cause spatial disorientation, which is basically where a pilot can't use the horizon or his instruments to keep the aircraft level, and they could quickly lose control of the aircraft and crash due to their low altitude and not being able to see due to the laser disabling their vision. So it makes it extremely dangerous for our pilots who fly the helicopters. They generally aren't flying at high altitudes like commercial aircraft are. They're flying at low altitudes because they're patrolling and they're easy targets for people pointing lasers at their aircraft. And this has happened throughout the state in other jurisdictions as well. Speaking to the director of aviation, he said other jurisdictions have reported similar issues of lasers being pointed at their helicopters as well, probably due to the fact that our aircraft fly much lower than normal commercial aircraft do, due to the purpose of the aircraft.
I've got to excuse myself in just a few minutes, but I'll be back. Let me just ask you about the aircraft portion of it on line 60. I saw knowingly or negligently. That we always are a little bit fearful of a situation where it's unintentional it could be negligent, but there's no malice involved. And if the author could speak to that, or Mr. Welch, or the officer.
Mr. Chairman, I think we need to make that keep. I don't know if that was a misprint or what, but I'm like you. I think we need to make that the same as under Section 2, knowingly and intentionally. What about counsel?
And counsel, let me just ask you to take a look and just be ready on an amendment, perhaps. Mr. Welch, did you want to speak to that or no?
No, I would agree with that catch, and you also note the difference between the crimes of the punishment is the high. Judge Crosby alluded to it earlier. There's a difference in the misdemeanor crimes, and of course, if you see a need to make that change and make those uniform as well, that would be.
Yeah, I mean, that's just a threshold judgment the committee has to make with regard to, of course, the officer and the high aggravated misdemeanor, and of course at the aircraft a misdemeanor, and we'll just see what the will of the committee is on that. But I hear you, Mr. Pack.
Question related to line 42. Relates to the defenses. It says, "It shall not be a defense to a prosecution for violation of this code that the law enforcement officer was within a motor vehicle or building at the time the laser device was pointed." Is the intent that trying to eliminate, for example, if someone's trying to aim through the window, and that's covered in line 43 to 44, which makes sense, but what does it mean if it's not a defense if the person was within a motor vehicle or a building? So if you're in the Capitol and you point the laser at the Capitol, is that not a defense? I was trying to point at the Capitol, not if the law enforcement officer is within the building. Is that the offense, or I'm trying to get at what the intent was?
It's pointed at the officer that happens to be inside a vehicle or a building. If you look at the line 43 there, it says the device was pointed at such officer where it was pointed through the glass. So I think it would be different if it's pointing at the building. That would be a defense, but when it is pointed at the officer who happens to be inside the building or vehicle, that would not be the defense.
Right. That's what I thought the intent was, but when I read it, it didn't make that kind of clear. Am I wrong about that? I mean, English is my second language.
Sagan.
Change where to when on line 43, because where is the location, when is the time?
Yeah, that would make sense. So it would be the device was pointed at such officer when the laser device is pointed through the glass window. I don't know that clarifies it anymore for Representative Pack.
My suggestion is, and please let me know if you think if we eliminate that whole motor vehicle building at the time, the only way you can point a laser at the officer in a car or a building would be through a window. Am I right about that?
Yeah, that's interesting.
Mm-hmm.
If the device was pointed at the officer when the laser is pointed through a glass window or other
transparent sensors and all that.
Yep.
On a vehicle,
Really
on a
doesn't
building,
matter.
something like that.
What about that?
Yeah, I think that'll work. We're going to change, just so we're clear on our end over here, the language that you want to strike would be the, it shall not be a defense of prosecution violations, code section, that the law enforcement officer should be that you should probably strike the law enforcement officer within the motor vehicle or building at the time. Is that what you want to strike?
Yeah. Yeah, if you strike from line 41, strike the, and 42, all the way to that.
Mm-hmm. And then change the where to when in line 43.
that serve the purpose?
Officer Brinkman, I think that accomplishes the goal of.
Yeah, if you're shining through a window, it makes a difference whether it's a building or a car. You could take out that and just say, and it would still cover the same goal.
Trying to protect the officers,
Yeah.
not necessarily building the car.
Yeah, exactly.
How would that read after?
Sure, I have one other question.
Okay. Let's see if they're okay with that.
Yes, sir, I believe so.
Okay.
But,
Okay.
Second question is, I know recently they outlawed, at federal level, they outlawed pointing a laser at an aircraft. It's a 5-year penalty with a $250,000 fine. I was wondering why it's a misdemeanor as proposed in the bill. I was looking at the officer, I'm sorry.
To my knowledge, the only law that addressed this previously was interference with a flight crew, and I'm not sure if there was another law passed. Part of the purpose of this law is bringing it to the state level so that we can actually help ensure prosecution on these cases. So if this the federal law interference with a flight crew, if we send this, it gets forwarded through the FAA, then it gets sent to the federal level, and their chances of choosing to actually prosecute these cases on their caseload is pretty slim.
Okay. All right. Representative Coomer.
Thank you. Back on Section 1, my understanding from the testimony is the purpose of the bill is really to protect, probably more to protect the citizens than law enforcement when it comes to putting law enforcement officer in a situation of trying to decide on a split second whether or not he's in danger. Is that correct? And so really the real danger comes when somebody's actually pointing a laser light at a law enforcement officer, and or so that the law enforcement officer sees the light and they think they're they're in reasonable apprehension of fear for their own life, right? So when I look back at starting on line 15, and we say that the term laser device means a device, and then it goes on and explains what kind of device. And then you look at line 21, section B, it says it will be unlawful for any person to knowingly and intentionally aim, point at, or toward, or project upon a law enforcement officer any laser device. Doesn't that language actually wouldn't it make it illegal for somebody to aim, point at, or toward the device, even though they're not illuminating the device or shining it on the officer? I mean, are we creating an area of criminal activity that isn't intended? And if so, wouldn't it make more sense to just, excuse me, remove the words aim, point at, or toward, and just leave it as knowingly and intentionally project upon? And if I'm misreading it, I'm certainly, members know I'm open to being corrected when I'm
well, that is
not reading it
hard
correctly.
to follow, to be honest with you. You kind of stumble through it reading it, but it's, what about Ms. Jill, what do you think?
I understand Representative Coomer's point, because if this was a laser and he was a law enforcement officer and I don't have it on, I'd technically be guilty.
Yeah.
In light of the definition of emitting, the projection is what you're emitting, so.
If you just strike aim, point, and just project upon a law enforcement, it's just projecting the beam upon a law enforcement officer. That's what we're trying to stop.
Right.
And I agree with that safety concern, that public safety concern that you're trying to address. I just don't want to make too broad a criminal statute if we can avoid it.
Okay.
That's a suggestion. Sounds good, based on what he said and what the representative said here, along with the legal counsel. And I don't know that I could repeat it, but
That would,
We'll,
as I understand it, it's going to be to strike the words aim, point at, or toward, or
That would be at the appropriate time.
Okay.
That's the motion I'd
All
make.
right. Is there any other comments or questions from members? Okay. Seeing none, we will take a motion on the bill at this time. Have a motion to pass. That's LC 352576 ERS parentheses SCS. Okay. Second by
Mr.
Representative
Chairman, I
Atwood.
have 1 second to consult with my colleagues right here before you vote.
Yes, sir.
You want to relate to him?
Based on those concerns, if we make it too narrow to where the laser has to be pointed at the officer, on the officer. So if I point the laser, it doesn't
Hopefully I'll
actually
get this
hit
off
the officer,
this
but
Friday.
it's right next to him. Is that legal now?
Is that going to be?
Well, it was all the way back to
Do
here.
we make
Yeah.
it too narrow?
Project toward or above.
There's like a lot,
Do we
like just a
lean
little
toward or
squint that's removable.
No, we're gonna.
It's on there now, just keeps it from.
We'll take care of that right now. Mr. Chairman.
Okay.
Going back to Mr. Representative Coomer's suggestion, if you would all look back at that language, the Officer Brinkman, Senior Officer Brinkman, has pointed out that part of it's not only just at an officer, so it would not just be the light shining on the officer, but it could be that someone sees the light coming toward them, or in their general vicinity there's a beam of light emitting. In other words, the person has not fixed his or her aim on the officer just yet, but is about to. And so capturing that language would be in broadening it up just a little bit. And so a suggestion there may be to say on line 22 where it says striking aim, point at, or toward, and then the word or, and then say project toward or upon a law enforcement officer. And then that, I think that would capture the incident where it may not be on the officer at the particular time, but it is in that direction.
Okay.
Is that?
Any further questions on that? Representative Pack?
If you amend the language to say attempt to point, would that cover that situation? Because using word toward is it's vague in criminal law. If you attempt it, and obviously the person intentionally going towards the officer, that would be criminalized, wouldn't it?
Well, wouldn't that be covered by the general attempt statute?
Right. That was my second point as well.
All right. Well, let's see what the pleasure of the committee is. We've got a motion to pass and a second from Representative Atwood. Are there amendments? Representative Coomer.
Yes. Excuse me. Move to amend lines, beginning in line 21 by striking the words aim, point at, or toward, or.
All right. The Representative Coomer has moved to amend line 21 by striking the words aim, point at, or toward, or. Is that correct?
Yes, sir.
Line 21 and 22. Is there objection to that amendment? Hearing none, the amendment's adopted. Other amendments?
I have one other amendment.
Representative Coomer.
Line 63.
Okay.
To remove or to strike the words or negligently.
Okay. Line 63 to strike the words or negligently. Is there objection to that amendment? Here. No, that's the second amendment. The first one, his first one was adopted. Oh, you would like to move to amend his? Okay. All right.
I was just striking those. I know there was some discussion about similar language in another place, and I didn't.
Well, it reads knowingly or intentionally on the.
I'll tell you what. Let me, since I think Representative Pack has already kind of run that through the process, let me withdraw that amendment.
Okay.
And let somebody else make it.
All right. We'll. Representative Pack, you want to offer the amendment?
Yes, thank you. On line 42, I move to amend by striking the words law enforcement officer was within a motor vehicle or building at the time that A.
Okay, line 42, striking the words law enforcement officer was within a motor vehicle or building at the time that A.
Correct.
Is that correct? Okay. Is there any objection to the adoption of that amendment? No objection. That amendment is adopted. You want to offer the...
I actually have more.
Okay.
I wasn't done with the amendment, sorry.
Okay, go ahead.
On line 43, I think to make sense, I think we need to say, striking the words where the laser device is pointed. So 41 through 43, if the amendment's adopted, should read, it shall not be a defense to a prosecution for a violation of this code section that the laser device was pointed at such officer through a glass, window, or other transparent or translucent object.
Okay. All right, the amendment is line 43, striking the words where the laser device is pointed. That's it, right? Where the laser device is pointed. Okay. Is there objection to that amendment? No objection. The amendment is adopted. Next amendment.
Point of inquiry. The question to the author, related to the line 60, Mr. Chairman, was it your intent to strike the words or negligently and insert knowingly and intentionally? I don't recall exactly what you wanted to do with
yes,
that
sir,
section.
I think that would make it compatible with section 1, would it not, Representative Wood?
It would, yes, sir. That's what we're using here.
Yes, sir, knowingly and intentionally.
That's what I thought. And my apologies to Representative Coomer. I think that was what he was trying to do. So I would move to amend line 60 by striking the words or negligently and insert the words and intentionally, and same for 63, which I believe is Representative Coomer's intent.
Okay. All right, the amendment is as to both lines 60 and 63 to strike the words or negligently on each of those lines, and in each place to replace those words with and intentionally. Is that correct?
Yes, sir.
Okay. Is there objection to that amendment? Hearing none, that amendment is adopted. Are there any other amendments?
Mr. Chairman.
Yes, sir.
Just for discussion, the council has pointed out that in line 63, the word uses should rather be the word projects, and it should also read a laser device to be consistent with the definition that's given. I'm sorry, laser pointer, yes.
Okay. Does anyone want to move on that as an amendment? All right, Representative Ramsey moves. Let me see if I'm restating this correctly, Mr. Welch. So that line 63 would read, knowingly and intelligently projects knowingly and intentionally projects a laser pointer.
Yes, sir.
Is that correct?
Yes, sir.
Okay.
You sure don't want it to be device?
No, it's pointer.
She said pointer.
Section 2 of line 53.
We use laser pointer in this section.
Representative Coomer.
Actually, if you look at line 53, we use laser pointer, but in line 56, we use laser. So the appropriate amendment should probably leave in the word laser, but add or laser pointer.
No, I think what you mean on line 56, it should say the term laser pointer. I don't know if there was an intention to have two different terms, or
Isn't the line 15 define laser device?
yeah, but it's a different code section. In section 2, you have the first. It says on 53 laser pointer,
okay.
and then on line 56 it says the term laser.
Well, but the term laser is also used throughout the code section. At line 60, projects a laser.
Right.
And
Laser pointer.
at this time in 63, we have the word laser.
Yeah.
And 64 has laser or laser pointer.
Should be both laser and laser pointer.
I think to make it consistent.
Aims the beam of a laser pointer or projects a laser. Maybe that's the language you want to replicate. Aims the beam of a laser pointer or projects a laser.
You agree that it should include laser and laser pointer then?
It looks like that's being sent.
Representative Ramsey, you want to amend your motion?
I'll move again to acquiesce to the suggestion of committee council.
Okay.
How about knowingly and intentionally aims the beam of a laser pointer or projects a laser in the airspace?
You got that?
I don't know enough about the.
Could you read us that one more time?
Yes, starting on line 63 would be knowingly and intentionally aims the beam of a laser pointer or projects a laser in the airspace is guilty of a misdemeanor.
Okay. Will that be your amendment? Representative Ramsey, thank you. Any comments from the committee on that amendment?
I'd say
Sorry.
one more question, just a question. Have we defined the term airspace somewhere else? I know I don't think it's here, but is it defined in the code
Travis,
section somewhere?
is it?
Not to my knowledge.
Okay.
Could we leave it at the aircraft, maybe? Would that work, rather than the airspace? I mean,
Well, this is actually a separate. You have subsection B that begins on line 59 that deals with the aircraft.
okay, I'm sorry, I was in the wrong, okay.
We could just strike this whole subsection C.
But I think Representative Coomer is kind of pointing out that that's getting into a fairly broad provision there. Yeah.
Okay, make it some list if you will.
Yeah, I think that given that given that we don't have a definition for airspace, and that it is important to the citizens of Gwinnett County and to their law enforcement agency that this proceeds so they have an enforcement mechanism to go against people that are deliberately using the laser to distract law enforcement officers from doing their jobs and potentially harm them. Talk to the author, and I think it would be wise just to go ahead and strike subsection C at line 62 and 63 and re-letter. And that way you eliminate the issue of airspace, and we take out all the amendments we just did on aiming beams and.
I think that would probably be the best solution. Will you withdraw your amendment request?
I will restate my amendment.
Okay.
And also amend that it deletes line 62 and 63 and renumbers D on line 64 and reletters it as C.
Okay. All right. Has everyone heard the amendment? Everyone understand that? Lines 62 and 63 would be deleted. Line 64, subsection D, would be relettered as C. Is there any objection to the amendment?
Yes.
Correct. Representative Ramsey will add that to your amendment to also on line 59 to change subsection D to subsection C. All right. Is there any objection to that amendment as stated? Hearing no objections, the amendment's adopted. Are there any other amendments? Representative Pack, you have some? Okay. All right. Any further discussion on the bill? All right. Well, then we will call the question this time. All those in favor of passage of Senate Bill 441, LC 35, 2576, ERS, SCS, as amended by the committee, signify by saying aye. All those opposed, no. All right. Bill passes.
Mr. Chairman and members of the committee, we appreciate your time and your fine work, and thank you so much.
Thank you, Senator. We'll call Senator Miller's bill next. It's going to be Senate Bill 225. Okay. Where at? Okay. Yeah. Okay. Right. All right. Senator Miller, good to have you.
Thank you, Mr. Chairman.
If you will, present to us Senate Bill 225.
Be my pleasure. This bill was brought to me, or this cause was brought to me from my local law enforcement and district attorney, and it really stems from a case that began in Hall County a few years ago. A gentleman by the name of Andrew Scott Haley made a video and put it on YouTube claiming to be what he called the Catch Me Killer, and he claimed to have killed Tara Gilmstead and talked about her body and where her body was buried. And he claimed also to have killed 16 additional people, and all these individuals are either missing or were known to be dead. And he caused a great deal of expense and trouble for law enforcement throughout the state of Georgia and in North Florida. And he was charged in the Superior Court of Hall County with tampering with evidence and making false statements. He appealed and went to the Georgia Supreme Court, and the court overruled, saying that his First Amendment rights were violated. And what we're trying to do here is to address the situation of making these claims on the internet or in general, and that's where we have Senate Bill 225.
Okay. All right. Any questions from members for Senator Miller on the bill? No questions? Oh, I'm sorry. Representative Pat.
Senator Miller, thank you for bringing this. That sounds like an awful situation. Quick question. I know this is a misdemeanor offense.
Correct.
Wouldn't this conduct be covered under the 16-1020, which is a false claim, obstruction of justice, which is a felony?
It's my understanding that it would possibly be covered under that. We would really like for it to be called as a felony, not a misdemeanor, and we would really like that to be the amendment that we make in the House, or we make it when it comes back to the Senate. But my understanding that it is not covered. Making a direct false statement, my understanding is that it is covered. However, making an indirect false statement by means of electronic media is not covered, and there in fact is the loophole that we're trying to close.
Okay. Any other questions? All right. I think we have Mr. Bankhead from the GBI that would like to speak.
Thank you, Mr. Chairman. It's John Bankhead with Georgia Bureau of Investigation. This came to light when our office down in Perry was investigating the Tara Grinstead case. She was missing, and they were also working with Florida authorities on a woman down there that was missing, or still is missing. Both are still missing. And the father of that victim in Florida called us about this video. And we spent a lot of time tracking this down, and were able to use our computer people to follow up and identify the source, put a lot of hours into investigating this because it was something we could not ignore. And so we put a lot of time in it. It went to, he was convicted after a fairly high publicized trial. And we feel strongly that this should be a felony because we feel it's more in line with false statements to police than it is false reporting of crime. So we would strongly recommend the committee consider making this a felony, and because if you keep it as a misdemeanor, it would reduce the crime that this guy has paid for. So we would make that recommendation to the committee.
And do you agree this would not be covered by current law?
That's my understanding, that we want something specific that addresses this type of activity because it wastes our time and other agencies' time in pursuing these types of investigations. This was very highly publicized in the metro area when it went to trial up in Hall County.
Okay.
And the DA up there, I talked to him about it. He strongly recommends this being a felony and this particular law be on the books.
All right. Representative Hightower.
What's your opinion that are getting a strong push to do criminal justice reform, and that nonviolent offenses need to look more towards probation sentences and sort of keep the nonviolent criminals out? If we do this and we make this a felony, and even though it's to be another nonviolent charge that we've made a felony. Now I understand your position is because of the amount of resources it takes away from your office. Would that be the argument there for y'all?
That is the argument. I mean, we could have been using those hundreds of agent hours to investigate other crimes rather than wasting it on this particular individual. We don't see where this is going to happen very often, quite frankly.
Mm-hmm.
So I don't think this is going to have any impact on the prison system. We just want to address it and address it strongly, hopefully as a deterrent for anybody that has these types of law ideas.
Okay. Representative Pack.
A quick question. I forgot to ask you this before, Mr. Chairman. What is reasonably intended to cause law enforcement?
That's a difficult question to answer, quite frankly. I think
does the word reasonably add anything? That's, I guess, my question. Because
I would really lean toward on line 16, beginning with the word "the" and ending with the word "a." Strike that entirely and put causes law enforcement rather than reasonably intended. I think that's probably a stumbling block for us there, is that reasonably intended. What is their, then we're trying to determine, well, what is their thought, what is their state of mind, what is their, are they reasonable at all? We don't know that. We cause that, I mean, I would be, defer to the wisdom of the committee if that be the case.
Mm-hmm. And to follow up on that, on the intent thing, and I'm not familiar with the Supreme Court case on the First Amendment defense. And my question is, how does the language in the bill resolve any First Amendment issues? What I mean by that, it is also subject to the challenge.
That would be a question for the courts.
Right.
I mean, I'm not in a position to answer that. I'm not trying to defer or evade your question.
Representative Hightower.
Representative Pack, I agree with the reasonably on what you were saying. If you struck from felony and then go straight to causes or to cause a law enforcement agency, if you do that, you could potentially catch more people than you're intending to. Mm-hmm. And what I mean by that, let's give you an example of, let's say you have some children on Facebook, and you have one child who says, they're just kidding around with a buddy, and he says to his buddy, "Hey, yeah, I beat up so and so," but he knows it didn't happen. Well, the buddy's mad at him, and the buddy transmits that to law enforcement to turn him in because they're mad at high school about each other. If you don't put reason or some type of intent right there, intended to cause law enforcement or something like that, you may be opening yourself up to mischievous children.
I understand.
Does that make sense?
Mm-hmm.
And I think that kind of addresses the reasonably part of the reasonably intended. That catches the people that are actually like y'all's guy in your example. He should have known. I mean, he reasonably intended to do this. He had a whole website there, as opposed to catching innocent kids that are just bantering back and forth. Does that make sense?
It does. It does.
One other observation I could make, if it could be connected, I don't know, it could be connected to the type of crime they're saying the claim occurred that they were involved in, rather than a misdemeanor aggravated or.
Well, this one does say commit a serious violent felony.
Okay.
Yeah.
So I think that would kind of get us around the kid in a fight, and
I think if we leave the language,
if we leave it like it is,
pretty close. If we struck it and just said causes law enforcement, if we struck and go from felony to cause a law enforcement, I think that would open it up a little too much.
Okay. All right. Any other questions or comments from the committee? All right. Are there any amendments Well, let me back up. Let's take a motion. Okay, we have a motion to pass. All right, we have a motion by Representative Ramsey. Is there a second? Second from Representative Coomer. Are there any amendments? All right, Representative Coomer.
Amend line 16 by striking the words reasonably intended and inserting the words made with the intent.
Okay. Line 16, we'll strike the words reasonably intended and replace with made with the intent. Is that correct?
Yes, sir.
Okay. Does everyone understand that? Are there any objections to the proposed amendment? Okay. Seeing none, the amendment's adopted. Any other amendments? Okay. We will call the question then. All those in favor of passage of Senate Bill 225 LC 295078S as amended will signify by saying aye. And those opposed, no. All right. Bill passes.
Thank you very much, Mr. Chairman.
Johnny Grant was here. Here he is. Yeah. Senator Grant.
Thank you, Mr.
Call
Chairman.
SB 366.
Yes, sir. And I have some folks with Department of Juvenile Justice here with me if you'd like to
All right.
have them come up as well.
Yes, sir.
And just for clarification, are we all working off of LC 352516S?
That's correct.
Okay. Mr. Chairman and members of the committee, this Senate Bill 366 is an attempt to update the code to better control items that are coming into and onto DJJ facilities to protect the youth in our state custody and the employees of DJJ. So it helps to redefine what contraband is, particularly as it pertains to cell phones, and also tries to put it together a scheme that's workable and doable for DJJ facilities. I'll be happy to go through this line by line if you would like to. We can hear from people from the DJJ, or we can see if there's anybody that wants to talk about it. As this came through the Senate, we worked with a lot of folks, both from the defense bar and from criminal justice, to try to perfect this. And while I'm sure that there are some things that may have been oversight on our part that y'all might be able to help educate us about, we think this comes pretty close to meeting the DJJ needs and still protecting the due process rights of our children that are in custody.
Okay. Would you like to just go ahead and go through the bill? How do you prefer?
If that's what you prefer us to do. There were some style changes that are in section 1, and then the section D, starting on page 25. A lot of that was, all that language was stricken because it became redundant as we added the new section 2.
Okay.
Section 2 first establishes for the commissioner of DJJ or his or her designated representative to establish and post guard lines, which then become I guess a demarcation line for some of the remaining part of the bill. Line 58 is of, I think, a particular interest because it says unlawful for any person to cause to be introduced across the guard lines, because one of the things that DJJ and our adult prisons have had problems with is material that's actually thrown across and not necessarily brought into the facility on a person, but thrown across. That section goes on to further have a description of guns, pistols, knives, or any explosive devices as being contraband. And then as we go on, we continue to develop those parts that make it unlawful. It's a crime to buy, sell, or trade any item with a youth in a DJJ facility unless it's approved by the facility director. So much of this language in the bill basically just prohibits this contraband from coming in. It does make some provisions for some discretion by the facility director in some areas, but it basically helps to further protect these facilities from some of this unlawful material that's coming across the lines.
Okay. Any questions for Senator Grant? See none at this point. Would you like to let's have our representatives from the DJJ speak to the bill?
I'd be happy to. We have former Senator Carol Jackson here
Yes,
on my left.
Thank you, Mr.
Thank you.
Chairman. Also, we have with us today Sarah Drake. Sarah is our Director of Investigations, and she's widely recognized for her work in contraband and has done an awful lot of work putting this together. And if y'all don't have questions, I don't know that we need to say anymore.
Okay. Any question, Mr. Chairman? Okay.
I just wanted to check with council about this guard line language. I guess on line 53, I know the intent is to have guard line of fill in the blank, right? Whatever that is. Does that achieve that in council's opinion, or are we mandating that the sign actually says guard line of underscore with a quotation? I just want to make sure that achieves the end that it's meant to.
I wasn't the original drafter of this. I know, I think that the original draft of this pulled some of this language from the statutes that have to do with guidelines and prisons, and I can see the question mark.
Okay.
But I think it replicates what's in the current law. Not necessarily that we should repeat bad stuff, but I think that's where it came from.
And of course, guard line's a defined term somewhere.
No, I don't believe so. No, that was something that occurred to me as we keep using the term guard line. This chapter just continues on. I believe this is the introduction of a new term. Maybe Senator Grant can.
Is it not defined with regard to prisons?
Well, it's in for 49.4A is where we are.
I don't know if it's defined early enough in the code section to be general, in the OCGA to be a general term. It may only be described in what Title 42 or whatever has to do with prison. So that may be something that needs to be corrected.
Okay. Mr. Chairman.
Just the use of the term guard lines is
The
not defined in this chapter.
bringing in contraband, I'm looking at line 71 in that section. Now I'm taken into a center in violation. That'll be a felony, 1 to 4. And are we including, I can see the weapons, drugs. Were cell phones added in this?
Yes, sir.
So you bring a cell phone into a juvenile detention center and
If you would like for her to address
Yeah, I mean, if you could just go ahead and address what you're seeing. I mean, just give us a worldview of what's really happening, and then
Sure. And my name is
the
Sarah
impetus
Draper,
behind
Director of
it.
Investigations with DJJ. In the past 6 months, we've probably confiscated over 100 cell phones that have been brought in. They're either being sold to the youth or they're being brought in by visitors. They're accessing Facebook, they're accessing the internet, so forth and so on. We're mirroring what the Department of Corrections is seeing in the adult system right now, just on a smaller scale. When you bring in contraband, whether it be a cell phone or whether it be tobacco products or marijuana, you're basically increasing the contraband trade, which leads to the assault rates that we're having. That's what we're kind of trying to do. Right now, it is not against the law for anyone to bring in a cell phone. It's not against the law for anyone to bring in tobacco products and to give it to a youth in our custody. So this is what the language of this bill is doing, is making it a felony offense to do that, because it is leading to the assault rates that we're having inside of our facilities right now.
Are you seeing that the introduction of cell phones into the facilities are having, is this part of any kind of ongoing commercial enterprise that may be run within the facility? If you can speak to any specifics that you may be aware of, just from your experience.
Yes, sir. We are seeing it. It's bartering. It's also selling. Cell phones can go up to $500, depending on the type of cell phone. The kids are getting cash in by visitors, by officers, and by other means. When they get the cash in, they're actually bringing the cell phones, and inside the facility, they'll rent their cell phone out to other youth. So you're looking at a commercial enterprise, if you will, inside. You then bring in issues such as gangs and other things like that, and that's where the whole cell phone issue, marijuana, tobacco products, other types of contraband are leading to the assault rates that we're seeing. So when you're looking at a commercial enterprise, officers are making money who are bringing them in, kids are making money that are bringing it in. So the commercial enterprise is happening.
Another thing, if I may, Mr. Chairman, that we have found is that there is absolute proof that gang activities are being conducted from the outside, inside the prisons, and vice versa, through these cell phones.
Okay. Go on to another question. Okay. Representative Cooper.
Thank you. Something you just said gave me a moment of pause. You said that officers are making money from participating in this contraband practice, which indicates that, whether we like to admit it or not, there may be some officers or employees who are subject to allowing themselves to be corrupted. The reason that is a concern for me in this bill is on line 74, excuse me, we're making it a felony for anybody to disobey the verbal order of a staff member. And if we're dealing with staff members that we know excuse me, are subject to bad intentions, doesn't that really create a situation where people who may not be doing anything particularly bad can get into a lot of trouble because they have a disagreement with somebody acting under the authority of being an officer or a staff member and giving verbal instructions, maybe even just for the purpose of getting somebody into trouble? Wouldn't it be a better policy to actually list by statute or otherwise make it a requirement that the list be in writing, at least from the agency, to identify those items of contraband? It sounds to me like you have a pretty good grasp on what those items are. I think it would eliminate a lot of the concern that's raised just by that comment of officers making money in the process if we just had a writing requirement that there be a list of contraband items. And maybe it's not through legislation. Maybe the agency can make it so. I mean, I would be amenable to having the agency write the list, but at least having something other than the mere discretion of an officer subject to being corrupted being the gatekeeper on who's committing a felony.
If I may speak to that a little bit, when Commissioner Buckner spoke to the Senate committee about this, that was basically her intent, was that there would be a overall policy regarding contraband that the DJJ board would promulgate based on Georgia code, and that then that director and or staff members at that facility in those contraband items would be posted at the facility, and then those contraband items could be again transmitted to that individual. The prohibition could be transmitted by verbally or in writing by that staff member, and I think that's what the intent of this was. I don't think we are implying that the staff member would operate unilaterally and not without the DJJ rules and regulations in mind. I see your concern, but I don't think that was what we anticipated would take place. I think it would be more within the line of what is the normal operations of the facility.
Okay. Right. Representative Pack.
Going to line 93, the definition of telecommunication device. I know what the intent is. The question is whether or not would it be clear or broad to eliminate the list of the devices. For example, line 95, including a telephone, cellular telephone, such and such. So the reason I say that is as technology changes, you're going to have to come back and change the law again. But I think the intent is any device that is capable of connecting someone inside the detention center or outside, that would cover everything, including smartphones, devices. I thought the definition, the first sentence was broad, covered everything, and by listing the items, you may intentionally limit the devices that you're trying to get at, and also not account for future devices that might come along.
I understand what you're speaking of, but several years ago when you put this exact language, telecommunication devices, in the adult corrections code, it was suggested that we use examples and expand. And while this, I don't think this is meant to be an all-inclusive language, it it seemed like at that time there was a general term that was used that cell phones could be incorporated under, but law enforcement felt like we need to specifically spell out some of the things that were were to be banned. But again, the wisdom of the committee will prevail if you think there is a need to change that. But this does mirror the adult language, the language in the adult code.
Okay. Any other questions or comments from the committee?
Let me ask counsel if she has any issues that she has spotted from a structural standpoint, or. But that is a term that's been used already in that area of the code.
No, it's not in this area of the code.
Oh.
This is 49-4A-11, and the guidelines that Senator Grant was referring to is in the, with respect to prisons, which should be in Title 42.
Is that a defined term within the prison code?
I don't know.
It must be, because there's criminal offenses that apply to crossing guard lines.
Can DJJ speak to that, or?
I believe that it is in the 42 code. I believe that it is defined.
Okay.
And that may have well been an oversight on our part to not pick up that definition.
I just wanted to check, make sure we've got some sort of guidance in case there's a question on it. Okay, thank you.
Okay.
And I'll be happy to accept an amendment that would pick up that language from 42 or wherever it is, listed in the current code. Yeah, reference.
You want to do that now, or you hold it until next week?
Can I suggest that we give counsel the opportunity to, with the intent to perfect it, also to take a look at Representative Pack's issue on including but not limited to, get the defined term, or if we're not going to define it, go ahead and at least put the reference in it back to the prison code, just so that there's something there.
Absolutely, we're fine with
And then, Mr. Coomer, I know you had an issue that you wanted to maybe just work through. We're going to meet either on Monday or Tuesday. I'm not exactly sure yet, but this will be lead off whenever that is. Would that be acceptable to you, Senator?
Absolutely.
Thank you.
All right. Okay, so we'll hold that over. Go on to 370. Senator Carter. Thank you.
Yes, sir. Thank you.
All right, Senator Carter, we're working from, on this is SB 370, working from LC 295245S. Is that correct?
Yes, sir, it is now.
All right.
Thank you, Mr. Chairman, members of the committee. I bring before you today Senate Bill 370. This is what we refer to as our annual drug update. If you will remember, there are 5 different classifications of controlled substances. Schedule 1 is for investigational use only with no medicinal purpose stated. Schedule 2 through 5 are the more potent analgesics, pain relievers, those with dependency tendencies, and they are scheduled depending on the potency and depending on their likelihood of causing dependency. So that the Schedule 2 drugs are the most potent and the most likely for someone to become addicted to, the Schedule 3 less than 2, and then so on and so on. And what we do every year is we just simply add to these schedules, and that's what we've done this year. One of the things that we are doing differently this year that makes this such an important bill is that we are addressing the problem that we have had with synthetic marijuana or spice in our communities, a problem that is really infesting our communities and something that all of us are concerned with. In the past, what we've done is to try to identify the chemical formulas and list them in the bill, and that's what we've done. Unfortunately, the bad guys will simply find a variation of that, and it's not listed in the bill. Therefore, GBI and local enforcement agencies are not able to enforce it. So what we've done is to borrow from another state. The state of Kansas came up with the idea of identifying the base formula for spice for synthetic marijuana and then saying any variation from this would be prohibited as well. So we've added that language. You'll find that actually on line 50. It starts there, and any of you who understand that, I applaud you. That is pretty technical as far as chemistry goes. I would like to think at one time I understood it, and I think I did, but it is even difficult for me nowadays. But nevertheless, this we hope, will help us and help law enforcement especially in enforcing these laws, and I think it will.
Okay. Any questions? Let's see. Representative Ramsey?
I want to speak to Section 1 and why it was added. And first I want to thank the author for working on this issue. It's an issue that we deal with every year. I remember sitting in this committee room 2 years ago when we thought we had banned spice, sadly we've not. And this is largely manufactured in China. They found a way to tweak the formula, as the author said. And I saw firsthand, my community saw firsthand 2 weeks ago, a young man, I know his family, a fine young man in our community, died after ingesting this product. His parents, his dad, I don't know what I would do if that happened to me. I'd probably be in a deep, dark hole for a few months. But his dad has taken the tragedy and channeled his energies into speaking out to young people and advising them of the dangers of this, trying to impress upon them what can happen. I've had a couple conversations with him, and as recently as this morning, he said, Matt, if I can just reach one kid, my efforts are worthwhile, and Chase's death will not be in vain. In light of his advocacy and in light of what his family's trying to do, they've started an online petition. They're doing so many things to try to reach young people in our community and around the state. I asked his family if, in light of all they're doing publicly, to try to find a silver lining in their son's death and make young people aware of the dangers of these products and make legislators like us aware of the dangers of this product and the need to address this issue, if they would like us in a bill that we hope finally does what we tried to do 2 years ago and get these products off the shelves forever, dedicated to his memory. And both the parents were overwhelmed and thought it would be a very appropriate tribute and one that they truly, truly appreciate. With the author's permission, I asked council to draft lines 8 through 10. Senator Carter has been very, very, very helpful and amenable to the request, and I just wanted to explain who we're dedicating this bill to and why that language is there, and hope it will do some good in raising awareness in supporting the parents' mission, which now has become reaching other young people about the dangers of this and other products. And that's really a statement more than a question, Mr. Chairman. But again, I want to publicly thank the author of the bill for working with me on this request.
Thank you. All right, Representative Hightower.
This stuff is kind of new to me. The question that I have are these, the people who are using these, are they getting these from convenience stores? Is that where they're getting these from?
Some of them are, and that's the problem that law enforcement has run into. They, we will identify them, and then we have to send them off to the lab. While I think they're doing the best that they can, and certainly we understand that and hope that they are, it's still a very difficult process. But I know that law enforcement has tried to identify those retailers who are selling it, and they're taking enforcement actions now to make sure they're not doing that.
The reason I ask is I had a story of a client of mine, a young boy who was arrested for having this in his possession, was placed in jail on a VOP. It took me 2 weeks to get him out of jail, but he had no idea it was illegal. He bought it from a convenience store, and it took me 2 weeks to get this kid out of jail, and he had no idea he committed a crime. And luckily, I had a DA that was willing to work. But I was wondering if that's what's happening, because this was the first time it happened to a person that I was representing, and it seems like a situation that we need to start controlling from the distributor standpoint, from these convenience stores, because these children are falling prey to something that they believe is legal, because it's being sold at an open convenience store.
Right.
So good job for bringing this.
Okay.
Thank you.
Representative Ramsey.
That's exactly what is happening. These are good kids, and these products are being sold. There's at least 2 convenience stores in my city alone, that are selling the product right behind right there at the counter. That's exactly why this bill is so important, because they found a way, and it's often packaged, I believe, as incense, and we know it's not being used for incense. The kids, and I live in a very affluent community with, you would think there'd be a real awareness to this, and parents, since this has happened and really kind of brought it to the forefront, parents of all over the community are saying, God, my kid's walking in there, and they know it's probably not right, but it's a legal product. And that's exactly why this is so important. And I will tell you this, the law enforcement community, I spoke to the director of the GBI, they are waiting for this bill. They are standing on the ready. And it becomes law upon the signature of the governor, and they are ready to get out there and get this off the shelves immediately. So.
Okay. Okay. You got Representative Byrd.
I'm just curious, if it's sold over the counter and then kids are buying this, do they know that it's a bad product, or how do they know that it was a bad product in the first place for them to be purchasing this?
The kids?
Yes.
Well, obviously it's difficult for us to say what kind of impression they're under. I suspect that some of them know exactly what it is, but at the same time I suspect, as has been stated, that there are a number of them who don't realize that it is illegal, and especially don't realize the effects that it will have.
So then what is their intent of purchasing that if they don't have a clue as the representative down there said?
I
mean, I'm just kind of curious where they're getting their information that it is a bad drug and that it's sold legally over the counter.
I don't really know how to respond to that.
Yeah.
I mean, I can tell you from my client.
My client learned that it was bad when he was arrested and spent 2 weeks in jail. I mean, that's exactly when he learned, and that's why it was such a big deal for us, because he had no idea until he was arrested and placed in jail.
That is an attention getter. Representative Ramsey. Okay, he waves. Any other comments or questions? Is there anyone in the audience that wishes to speak on this bill? Okay, seeing none. Do we have a motion?
Mr. Chairman, I move do pass SB 370 LC 2952445S.
Okay, we have a motion to pass by Representative Ramsey. Is there a second? A second by Representative Hightower. All right, any amendments to the motion? Seeing none, we'll call the question. All those in favor of passage of SB 370 LC 295245245S by substitute indicate by signifying aye. All those opposed, no. Okay, the bill passes.
Thank you, Mr. Chairman, members of the committee.
I think that's all we have. That's all we have today. We'll be adjourned. Thank you.
This is really so we can go after those retailers. That's exactly what you're right.